Good evening. On behalf of the Order of Malta, I would like to welcome you to our 20th webinar on justice and human trafficking. We will focus on the gap between the current state of the law on human trafficking and its implementation in practice. The implementation of legal instruments aiming to prevent and combat human trafficking is unfortunately very weak. The International Labour Organization and the UN Migration Agency, IOM, estimate that at least 40 million people are victims of modern slavery. According to Kevin Hyland, one of our speakers tonight, and an expert, out of all these instances of human trafficking, 1 in 2,150 traffickers are convicted. In other words, if you are a trafficker, there is a 99.5% likelihood that you go unpunished for your crimes. Hence, this crime is so scandalously populous and constantly growing. While it's universally agreed that human trafficking is an affront to human rights and human dignity, it is not considered a priority by the International Criminal Court. Because of stringent requirements that must be satisfied to show that a case of human trafficking is a crime against humanity, as defined in the Rome Statute, many cases go unpunished. Moreover, according to the former UN Special Rapporteur on Trafficking Persons, Mrs. Joy Ngozi Ezeulo, adequate and effective remedies are often inaccessible for trafficked persons, despite the numerous human rights violations they suffered. While the right to an effective remedy is a well-established norm under international law, in reality, there remains a wide gap between the law and its implementation vis-à-vis trafficked persons. Tonight, we are very fortunate to welcome 3 distinguished speakers who are experts in the field. Alain Werner, a Swiss human rights lawyer, specialized in the defense of victims of armed conflict, is the founder and director of Civitas Maxima, an international network of lawyers and Tibet investigators based in Geneva, Switzerland, which represents victims of mass crimes in their attempts to obtain justice. Secondly, we have Professor Fausto Poccar, Professor of International Law at the Law Faculty of the University of Milan. He is speaking from Milan. And he was a judge and president of the International Criminal Tribunal for the former Yugoslavia, ICTY, in The Hague. He was also a judge of the Appeal Chamber of the International Criminal Tribunal for Rwanda, ICTR, and in 2017, Fausto Poccar was appointed ad hoc judge of the International Court of Justice, and he is also honorary president of the Sanremo Institute. And thirdly, we shall hear Kevin Hyland, former head of the establishment of the Metropolitan Police Human Trafficking Response in the UK, and from 2014 to May 2018, first independent anti-slavery commissioner for the UK government. He's speaking from Strasbourg for a meeting of the Greta Group of experts on action against trafficking in human beings of the Council of Europe. All 3 speakers will explain, according to their experience, the reasons for this gap, developing both the instruments, shortcomings and weaknesses, and a vision of legal models that could be completed to achieve an effective objective of reducing human trafficking. If you have any questions, you can write them in the Q&A question section. We will discuss them with our speakers at the end of the webinar. And please know so that we have also a list of handouts available for you. You please download them if you so wish. And now, after this brief introduction, I would like to give the floor to Fausto Poccar. Professor Poccar, you have the floor. Thank you very much for being with us.
Thank you very much, Michel, and good evening to everybody. As I have to start this interesting meeting, let me give some elements on the legislation, the existing legislation, which is important. Let me start from the Rome Statute of the International Criminal Court, because this is the I would say the instrument that would be more at hand today to deal with this crime of modern slavery. And when we speak of modern slavery, we have to take into account that slavery is perhaps, if not the oldest, one of the oldest crimes against humanity, largely before the concept itself of crimes against humanity existed, because it's enough to go back in the history and slavery exists as always. So in practice, from the beginning of our history, even the great civilization in the past had slavery, were based to a large extent on slavery. So it's an old crime, and it's a bit strange that today it's still a sort of neglected crime to a certain extent. Although legislation is not so remained so much in the back, I would say, because if you look at the Statute of the International Criminal Court, you have slavery as a crime against humanity in one of the first provisions of Article 7 of the statute. And then you have an explicit reference when the enslavement is dealt with the notion of enslavement is dealt with in the statute, in the same article, an explanation of what slavery means, enslavement means. And the statute clearly says that the enslavement means the exercise of any or all of the powers attaching to the right of ownership over a person. So it's what is the basic of slavery is that one person is in the power of another person and completely in the power of that other person. And the statute continues to say that this includes the exercise of the power, such power, in the course of trafficking in person, in particular women and children, which are more vulnerable than men, but slavery is also affecting men. Maybe in particular, you may deal with women and children as more vulnerable part of the population, but men are also slaves the same way. In particularly within the migration phenomenon. Migration is free. There are more possibilities of moving today than there were in the past, probably, but that does not mean that this freedom of movement is really a freedom also of rights because one of the basic practices of enslavement of individuals when they migrate for labor reasons, essentially, is that the trafficker makes an arrangement with the person who wants to go abroad, who pays an amount to be transferred abroad with the promise of having a job, essentially. When he arrives, he may get the job, but the job will be poorly paid, and the money one receives has to be used to repay the trafficker that was not paid entirely. He gets 50% of what he deserves. But the problem is that the salary is never sufficient to pay the full debt because there are the interests that come up. So this person is in fact a slave. Is a slave that have to remain slave all his life, apparently, although sometimes, of course, he succeeds or she succeeds in escaping. Women are forced to prostitution. Children are forced to labor and prostitution as well. And what is even worse, especially for children, they are transferred sometimes and frequently, mainly for trafficking in their organs. So they are killed, essentially, taken away organs in order to serve surgery on other people. And this is again is money that goes to the traffickers. So why very little is made? The legislation is there. The Rome Statute is there. And not only. Before that, we had as of 2000 the protocol to the convention, the Palermo Convention, on specifically this protocol is on trafficking, and that protocol gives a very interesting definition of the trafficking, which is quite wide, quite large, and includes many of the the features of modern slavery. Describes them quite well, covering a lot of situations. At the point that if we look at what is covered by the convention, the protocol to the Convention of Palermo on trafficking in person, there will be not only the provision on slavery that will come into consideration in the Rome Statute. You will have the forcible transfer, the deportation, sexual slavery, enforced prostitution. There are a number of provisions that could come into consideration. So a case of modern slavery would not come only under the provision, specific provision of slavery, so it would be covered by other provisions of the statute as well, not to just including at the end the inhuman treatment simply, which other inhuman treatment, which is again crimes against humanity. So there are a number of situations that are covered. And so why nothing or little happens? There may be various reasons, but the cases are very limited. Professor Veuthey has just mentioned in his introduction the limited percent or 0.00 something percent of cases that are prosecuted and punished. So it's clearly a type of crime that is not very popular, although it is very widespread and very much frequent. In my experience as in the ICTY, former Yugoslavia, we had to deal in one case of trafficking, but not really of trafficking, because we had evidence on trafficking, but the fact is that the case was a case of rape. The prosecutor had judged essentially rape, and we just could reach enslavement, sexual enslavement, under that umbrella, but not the trafficking, that the persons, after being raped, were trafficked among soldiers in war. And that was a clear case of trafficking in war, because the soldiers sold the women and children that they, in many cases, were children because they are minors, women but minors at the same time. So under the Convention on the Right of the Child, they were children also. And these were transferred to other soldiers for amounts which appear ridiculous in a way, because at the time in the former Yugoslavia, the money, the currency was, the hard currency was the Deutsche Mark, and one of these women could be sold for an amount between 300 and 500 marks, which is a small amount for in hard currency, clearly, but in war may be more important, but still is not an amount of which which should be. So in that case, we nevertheless succeeded in defining enslavement under customary international law. So adding one piece, one part of law that deals with this matter. So not only conventions, but also customary international law. And we clarified, the tribunal clarified, that enslavement may occur even when the victims still enjoy de jure a certain freedom of movement, but the situation in which they find themselves leave them no real choice of escape with the prospect of conducting an independent life. So it's we also the psychological side of enslavement was taken into account. But that was the only case that I saw in international criminal jurisdictions. I never saw another case of this kind. So it's really too limited. And I frankly don't understand why the International Criminal Court, in its now 20 years of life after the entry into force of the Rome Statute, never brought a case of this kind. Because we are speaking of a case that may be useful for millions of people, having definitions, having a court that takes care really of this is more important probably than convicting or trying to convict a head of state. That at the end will not nobody of poor people, nobody of common people will benefit much of that. So this will be cases in which one may have even support from states that are not able to deal in a sufficient way with organized crime. And we should not forget that under the Rome Statute, crimes against humanity means not only crimes that are committed against the population systematically or in a widespread manner, as in customary international law, but that the statute is more precise. It says that the attack against the population has to be pursuant to or in furtherance of a state or organizational policy to commit the attack. Now, when you speak of organizations, it's clear we are dealing with organized crime, essentially, because this is what happens. It's not states that organize this. This is clearly organized crime that does. So it would be, it's a part of a fight against organized crime. But I have the impression that an international court is not dealing with these matters because normally organized crime is not dealt with by international courts. Even in the Balkans at the time, the court of Sarajevo, the domestic court of Sarajevo, dealt with international crimes that the ICTY referred to them, but essentially was dealing with organized crimes. So it's more left to states to provide remedy in those situations. Why states do it so little? Did they introduce correctly the Rome Statute into their domestic legislation? This should be something that we should assess. I didn't make a full consideration of this. There are I saw some states that introduced it correctly, but did all of them introduce it correctly? And I say that because my own country, that ratified this Rome Statute among the first ones, did not introduce the domestic legislation introducing the crimes, the international crimes, into the domestic legislation until now. It's only now that recently the Minister of Justice appointed a committee to draft this domestic legislation, adapting the domestic legislation to the international legislation. It's true, we had in our law slavery as a crime, of course, but it's different if one does it as an international crime. It's more the international dimension is important. And I was chosen to preside over that committee, and now there is a draft law that will be probably adopted in a short time. And all these questions are dealt with in that law. But I don't know if all states did such an exercise. Maybe there is a reason that the problem is that, in my view, that the perpetrators of this crime are not high-level personalities. And there is a trend in international life to give more weight to prosecuting persons of high level, of a certain high level. Even the case in the ICTY we had, the person were not persons of high level in the combat. There were a group that was of lower level. And there is a trend to go only towards the high level. The same statute, Rome Statute, says it, that one should prosecute basically more the leaders, the high level people. So when you are an organized crime, you frequently don't have high level people. They may be high level in terms of criminality, but not in terms of level in the society. They certainly are not. So there may be a difficulty of this. I don't think it's a problem of difficult investigation, because it should be relatively easy to investigate these cases. And I don't even think there are obstacles by states in doing that, because many states will be happy to get rid of this problem at the end, instead of having everyday cases of this kind. So we have a legislation, an international legislation. I don't know if there are really gaps in the legislation, because international norms cover the situation, but there is less inclination to deal with these crimes. Probably because the ideas these are not of the level that should be dealt with. My personal view is that the level of the perpetrator may be important in certain cases, but if the crime is really egregious, it's important to deal with the crime and to create precedents in the crime, because to describe the phenomenon is different if people speak of migrants that are enslaved. Normally, population do not like too many migrants, so it passes by. But if there are decisions, judicial decisions, that describe the phenomenon in human rights terms and give examples, it would be different probably. So I really would hope that the ICC will start dealing with this problem, which is extremely important in my view. Well, I stop here. I don't want to take all the time from my colleagues. They probably certainly have issues more interesting to say that what I said because I'm not a specialist of this type of conduct. Thank you.
Thank you very much, Fausto. It's very interesting, and especially with your experience of ICTY and also the experience of ICC and with Italian legislation. So, Alain, thank you for being with us. You have the floor, my dear.
Thank you very much. Thanks a lot for this opportunity. Once again, it's a great honor to be there. It's very impressive to talk about after Professor George Pocard. I will do my best to try to give you a perspective from basically litigation that we conducted. So I will introduce myself very quickly. I will explain to you what we are doing, and in that framework, this case, which nearly almost succeeded, we will understand why it didn't at the end. And as Judge and Professor Pocard said, I think the assessment of my presentation will be as well that it's very unfortunate that on the universal jurisdiction side, so on the litigation brought in front of national courts as well, like in international court, very unfortunately, and I agree with Judge and Professor Pocard, it's difficult to understand really why, but there are not at all so many cases. So basically, I am a Swiss lawyer, and I worked for 5 years with the prosecution office at the Special Court for Sierra Leone, as well representing victim at the ECCC in Cambodia, and representing victim as well in the case of Habre in front of the court in Senegal. And now for 10 years, I set up myself from Geneva, a network of lawyers and investigators called Civitas Maxima. And the idea is to basically collect statements from victims, most of the time forgotten victims, victims who do not get justice, and then try to see whether there could be jurisdiction, mainly in front of national courts, because as Professor Pocard, Michel, and many of you know, it's the spirit of this international field community that the states should be the first ones to bring the cases and litigate. Obviously, the states where the crimes happen, but as well the states that could have jurisdiction on different grounds, and I will give you a very concrete example. So my case, it's now a completely public case because the case is dead, and you will understand why. So I can talk publicly and give the names. So it comes from what happened during the war in Sierra Leone. And this case, in my view, should have been litigated and prosecuted by the Special Court of Sierra Leone. So Special Court of Sierra Leone, as you may or may not know, in its statute, had the incrimination of slavery, Article 2 as a crimes against humanity, Article 2, letter C, and it was used in many cases against rebel leaders from the Revolutionary United Front, RUF, from the Armed Force Revolutionary Council, AFRC, including against the former heads of state of Liberia, Charles Taylor, who was as well prosecuted and found guilty of aiding and abetting enslavement by the RUF. So he was in Liberia, and he was basically providing weapons, giving money, training to the rebels in nearby Sierra Leone in order to get the diamonds from the mines of Kono in the east of Sierra Leone. Now, what was interesting about that tribunal, and very unfortunate in my view, the mandate of the tribunal was not as wide ICTY or ICTR. The idea was for the prosecutors to try only those who, according to the statute, bear the greatest responsibility. So we were in a setting where the prosecutor had to go for the top and not the foot soldiers. And indeed, this is what the prosecutor did, prosecuting Charles Taylor and some head of factions. But when it comes to slavery, so basically people working in the pits of Kono under gunpoint, and then you have the diamonds being taken and being sold elsewhere, then obviously you can ask yourself, is really Charles Taylor or the rebels the only one who should be held accountable? Because at the end, the deal was for the rebels to receive the weapons and other material necessary to conduct the war, and in exchange, they were giving weapons. They were giving diamonds. So it was weapons and other means against diamonds. And this is how the RUF, for many years, could keep the war going. And you can ask yourself, is Charles Taylor or any rebels manufacturing the weapons? Are they the one selling the diamonds that the slaves had to take from the pits? And of course, the answer is no. And this cycle of getting the slaves in the pits would not have been possible without some Western complicity of businessmen who were basically bringing the weapons from outside to Liberia and then to Sierra Leone, and then taking the diamonds from Sierra Leone, Liberia, and then obviously sold in the European markets. So this enslavement would have not continued without clearly the complicity of Western businessmen who were at the heart of this deal of weapons and other things against diamonds. Yet the prosecutors did not indict anyone from the Western world, and they had, in my view, evidence against some of them. Some of this evidence were public, reported even before the establishment of the special court by journalists and other people. So there were clearly leads about the responsibility of these Western people. So this is what I decided to do with my organization once I was not working anymore for special court. And the idea was to go against one man. His name was Michel de Sandelier. He was a Belgium-born Flemish, so Dutch-speaking from the Flemish side of Belgium. And he had been collaborating with Charles Taylor and the rebels precisely in that idea of bringing material and taking diamonds. Now, just to show you how complicated that case was, and how if you don't work with an international court, then things are super complicated. And this goes, in my view, to Professor and Judge Pocar's argument that there should be much more involvement from states and much more money, means, and effort, because when you try to do that on your own, just a bunch of lawyers with victims, it is possible because the laws, exactly as Professor Pocar said, the laws are there, everything is there, but it's complicated. So we are in a scenario where the international court was not interested. So the jurisdiction, of course, could have been given in Sierra Leone because the diamond and the enslavement happened in Sierra Leone, but Sierra Leone was not interested as a state because, of course, Sierra Leone said, well, there was an international court in our country, so this is where their job to do that. If they didn't do that, then, it's not us who are going to do anything. So the country where the crimes happened, Sierra Leone, was not interested. And then you could have thought about Liberia because everything transited by Liberia somehow. So you could have constructed a legal argument that there was continuous of crimes and as well in Liberia. But up to today, 20 years later, 2023, 2022, Liberia has done nothing for accountability for war crimes. So Liberia was not an option. So then you are left with other options. Michel de Sandelier, as I said, was born in Belgium. Later, he became American citizens. So basically, you could have two choices here. Because of his nationality, you could think that you could try to bring a case in the United States against Michel de Sandelier, or you could try to bring a case in Belgium. And this is very interesting because at the end, you have to look at your options. The options of the United States could look better because Michel de Sandelier was living there. So I started trying to investigate this case in 2010, 2011. Michel de Sandelier was living dual citizen, but he was living in United States. Now, United States, because it's common law, had very complicated laws, and it was not possible to prosecute him for crimes against humanity of enslavement or war crimes of pillage, and certainly not with a complaint by victims who could have rights, because obviously, unlike Italy, unlike Switzerland, unlike France, unlike other countries, United States is common law and do not have active participation of victims. So then we decided to file a criminal complaint in Belgium, because Belgium, again, is a civil law country, and because Belgium had the laws, at the time it was Article 136 ter, Section 3 of the Belgium Criminal Code, which said that whether enslavement defined as a crime against humanity committed in peacetime or in war, insofar as the act in question was committed as part as a widespread or systematic attack on the civilian population, and with full knowledge of this attack, is punishable by life imprisonment. So this is where in 2011 we filed a criminal complaint for enslavement as a crime against humanity and pillage as a war crime in Belgium on behalf of Sierra Leoneans, former slaves who were forced to work in that pit. Now, the problem we had, again, was that Michel de Sandelier was not living in Belgium. So he could not be arrested in Belgium. And the Belgium decided, which in my view was a big mistake, to request the assistance of Sierra Leone because, and we can understand that, the Belgium wanted to go to Sierra Leone to visit the mines and meet the people in Sierra Leone in Freetown. So they did an international request, and here we are now in 2012. We had information that Michel de Sandelier was traveling back to Europe because one of his relatives, his children, was residing in France. So he was traveling back. So we were hopeful that he could be apprehended, arrested at one of his travels to Europe. But the problem is that because Belgium requested Sierra Leone, then the information was leaked. Somehow, Michel de Sandelier in the United States learned, we believe, that something was happening in Belgium. And why do we think that? Because he stopped traveling. He stopped going to see his children in Europe suddenly. So we were in a scenario where we had the filing in Europe with jurisdiction, but we could not get the arrest because he was in the United States and the Sierra Leonean didn't let the Belgium go and investigate in Sierra Leone. So in a way, it was stuck. And strangely enough, and this is a big problem, sometimes in national court and national jurisdiction, the collaboration between the United States and Belgium was not very good. And there was not much collaboration for some reason I still do not understand very well. Now, 3 years later, in 2015, the case developed. And the reason being that I think that Michel de Sandelier thought that we had forgotten about him. So he started to travel again 3 years later. And at that point, when we learned that he was traveling through some intelligence, then the Belgium had the good idea to issue a European arrest warrant. And Michel de Sandelier was arrested in September 2015 in Malaga, in Spain, on a Belgium European arrest warrant. He was sent to Belgium and he was imprisoned in jail in Belgium. And from there, things started to develop very well because, of course, this case had publicity. So what happened is that the Sierra Leonean let the Belgium visit Sierra Leone. So the Belgium, the same 2015, 2016, went to Sierra Leone, traveled to the mines, met the former slave who could see the mines and where the slaves had been enslaved. And things were going very well. We are now in September 2016, and it looked like Michel de Sandelier were going to be tried in Belgium. Now, please imagine this. This would, and this goes absolutely in Professor Poca argument. This would have been, as far as I know, this would have been the first ever case in international law for pillage as a war crimes and enslavement as a crimes against humanity against a businessman, and for any kind of traffic, be gold at the time, be diamond, this was diamond, it could be whatever. So it was really, this shows you how not many of those cases do exist. And of course, it was very exciting because I think that Michel de Sandelier was guilty of the act, and as well for the development of jurisprudence and international law. But unfortunately, very, very unfortunately, what happened then in September, October, I think in October and September 2016, in a jail in Brussels, Belgium, is that Michel de Sandelier killed himself. He committed suicide, which obviously was the end of the case. And this was cruel and very unjust, I believe, for the victims, who again from 2010 for 6 years had been trying and really traveling, doing everything they could for that case. We were very close of having a public trial in Belgium, and at the end, it didn't happen because Michel de Sandelier, in his free will, decided otherwise and basically smuggled some medication for some weeks that he was keeping in his cell and putting in his mouth when there was checks. And one day decided to swallow all of them in one go, and he was dead. And of course, because he was dead, then that was the end of the case. Now, let me just tell you quickly, and then I will be done. Let me tell you that very unfortunately, I think that this situation with enslavement, where really there are very few cases and they are very complicated to bring forward in national court, because I believe there is a lack of commitment from national authorities, and it's not completely normal that it's done to lawyers from NGOs to do all of that. And this should be really driven by states and war crimes unit in Switzerland, there are war crimes unit in France, in the Netherlands, there are war crimes unit in Germany. In many countries, you have war crimes units. Some of them have lots of staff. So that should be driven by this war crimes unit and not by the NGOs, in my view. Of course, the NGOs could assist with victims, but they should be really a lead by the national state. But just to tell you that in my experience, this is not limited to enslavement. And let me give you quickly an example about one of our cases, just to tell you that it's not normal that these cases make such history because they are the first ones. Last year in Switzerland, we had the first ever conviction in front of the Federal Criminal Court against a Liberian head of militia. I am myself, as a lawyer, filed a criminal complaint in 2014 against him. His name is Aliou Kosha. He was convicted to 20 years of jail for about 19 murders, cannibalism, 1 rape, forced labor as well, so many acts. Now, it was the first case, 2021, 20 years after the ratification by Switzerland at the International Criminal Court, first case for war crimes in front of the Federal Criminal Court, and first ever Liberian convicted for war crimes when the war ended in 2003 and started in 1989. So this is showing you, in my experience, that yes, and thank God there are cases in national courts. We know the Syrian cases in Germany, the Rwandan cases in France. We have many of these Liberian cases in several countries. But still, in my view, because the states should be the one, according to the Rome Statute, and complementarity driven the effort, very unfortunately, there are not enough of those cases. And the states, in my view, are not putting enough money and enough effort in that fight, which should go obviously hand in hand with the work of the International Criminal Court. Thank you very much.
Very much. Thank you very much, Alain. It's a very powerful example, and I think you're right. And my best wishes for all what you're doing. Indeed, very interesting, very interesting. And now, really, thanks, Kevin, for being with us. Thanks for your patience. Also, you are really an expert in the combat against human trafficking. You are, as I mentioned, member of the Greta, which is very effective, and we are very much looking forward to listening to you. You have the floor, Kevin.
Thank you, Michel, and thank you for inviting me today, and also congratulations on this series that you've run over the last year. It's been remarkable. I want to start really just taking a few words from our previous presenters, from Fausto and from Alain. Neglected crime, I think, is what Professor Fausto said, and that really sums this up. It is definitely a neglected crime, something that is marginalized. And why is it marginalized? Because it affects marginalized people, and it's not important. And we all profit somewhere from this existence. I think Alain as well talked about what I would sum up as outsourcing, that states outsource their responsibility. And I couldn't agree with him more. This is a state's responsibility. This is something that states should put together and have formidable measures in place to prevent it. The suppression is preventing it, to support victims and to prosecute. And if we look at globally, this crime, it's estimated in 2014, the ILO said it was creating $150 billion a year. And yet, if you look across OECD countries, it's very hard to reach $1 billion a year fighting this. So less than 0.75% is actually fighting this global crime. But then also this crime is entwined with legitimate economies. As we hear, businesses, whether they're in East Africa, whether they're in Latin America, whether they're in the UK or across Europe or Australia, legitimate companies are benefiting from the exploitation of people who are elsewhere in the world. And that's something we need to fight. And of course, if we look at the laws, we have the Palermo Protocol that's been around for 22 years. We've got the Council of Europe Convention that's now around since 2008. We've got commitments at the G20. We've got commitments last year at the G7. We've got commitments at the UN. We've got the OSCE commitments, EU directives, and yet nothing is really happening. Criminals are operating with impunity and making 150 billion a year while 40 million people suffer. That in itself should be a wake-up call to the world and to states. And as a former police officer and running trafficking teams, I used to get people say to me all the time, it's really difficult. It's really difficult. It's frustrating. The victims, they won't cooperate. So let's blame the victims, shall we? Because they won't cooperate, there's nothing we can do about it. Actually, I used to investigate murders. When I investigated murders, a victim never spoke to me, but I still used to convict. When I investigated drugs crime, drugs never speaks. So the commodity in trafficking is a human life. Just remember that, it's a human life. And if 10 kilos of heroin was coming into the country, you would get helicopters, firearms, as many officers as you want. If a van load of people who were destined to work on a building site were coming into the country, you might get an immigration officer doing a stop. And that's the reality, and we need to understand that. And that's why we're failing. We're not putting the resources. We're not using the technical resources of policing. We're not using the state's ability to prosecute. We're not doing what Alain said about this being a state responsibility, like having a war crimes unit or like having terrorism. And the funny thing is, we know that human trafficking funds terrorism. Women were being sold in Libya to fund terrorism in northern Iraq. And a partnership that I drew up with other countries, we managed to get sanctions on the people who were benefiting. But why is it we're not doing things like that all the time? And when people used to say to me, victims will never talk to you, I proved them wrong time and time and time and time again. If victims are treated properly and you have professional people debriefing them and they get what they're promised and what they're told they will get, they start to trust you. They start to trust the people who are protecting them, the people who are looking after them, the police officers, the state. But if they're like in the moment at the UK, where they might be waiting 2 to 4 years for a decision on a national referral mechanism, and there's 30,000 in that queue ahead of them, they're not going to trust the state. If they get shipped off to somewhere where there's nothing that's actually helping them to get better, they're not going to trust the state. They're not going to trust anybody. So you can do this, and we can do this properly, but it needs dedicated, well-resourced professionals who are funded by the state, assisted by NGOs. I worked with NGOs in many ways, and it was the professionalism and that extra added value that NGOs could bring, particularly when dealing with vulnerable victims. And religious sisters had this way of giving compassion to victims that police officers just don't naturally ooze. And one case I did, in the morning we raided a premises. By the afternoon, because of the love and care of the victims, the victims were telling us the whole account. And we managed to catch the traffickers and the rapists of children. So we need to think better. But across the world in 2020, 9,800 prosecutions mounted for human trafficking by states out of 40 million potential crimes. That's nothing. It is nothing. In one state alone, there will be more than 10,000 prosecutions for drugs. That's for sure. But across the whole world, 9,876 prosecutions mounted for human trafficking, 150 billion US dollars and 40 million people. And that's all we can produce. But if I told you in 2015, there was 19,000 prosecutions, and yet we keep hearing that we're doing better. Well, we're not. The facts show it. These facts from the US State Department. We're not doing better. But we also need to look, things like the Palermo Protocol in the year 2000, we were all scared that the internet was going to crash as we went into the year 2000 and that all our computers were going to fail. So think where you were in the year 2000 and think where we are now in 2022. communications, technology, the way we travel the world, the way that trade has changed. And yet we're still trying to look at this in isolation to an individual area. The victims need to be supported locally and be given that support. The crimes need to be investigated and all avenues and areas looked at. And I remember running investigations where the next thing we were working in 4 or 5 countries. And that wouldn't just be in Europe, it may be in Asia. And the same network was connected. Now, it was hard, it was tough. But as a professional police officer, it was exactly what I wanted to be doing. And my teams wanted to be doing it. It was the empowerment of leadership. And the Santa Marta Group, which some of you may know, is a union of civil society, police, and Catholic bishops and religious sisters. And it comes together to have that strength. And I'll give you a little story of how that works. Yes, it's got a big strategy plan it wants to work on. Yes, it wants to influence the UN. Yes, it wants to influence the G20 and governments and other agencies and supply chain transparency. But when I had a case of a Nigerian woman and the trial was going to collapse because we couldn't find a witness who we knew had gone back to Nigeria, and she was being accused of being some sort of rogue person. If I had done through the official channels, it would have taken me 6 months, a year. The trial would have collapsed. I picked up the phone to the religious sisters in Nigeria and they found the person for me in 2 hours. So operating at strategic levels, bringing in plans, but making sure it works on the ground is crucial. And then I think we need people like what Professor Fausto has said, bringing this to the international courts. Why is it we haven't had this at the international courts? So working with Santa Marta Group and working on the global stage, there's 6 things that I've said we need to do to change the culture and to change our approach to human trafficking. And within it all is a core that states need to protect victims. That's a given. And they need to set up national referral mechanisms that are effective, that support victims, that give them the right to legal aid, that gives them the right to compensation, that brings in the non-prosecution element, that gives them leave to remain and to stay in a country if necessary. All of those things should be automatic and work systemically. But the other things I think we need to do is, firstly, we need to look at global procurement. The G20 committed to making sure that procurement and government buying would be free of modern slavery, something that I pushed for. And that 1 in every $5 around the world is spent by a government. Well, if we made sure that money was clean and it wasn't funding human trafficking, we're going a long way to clean things up. Look at the procurement of the US, the UK, Australia, Germany. And Germany's bringing in new legislation that's going to be a step towards that next year. But then we need to also look at tainted money, a term I've been talking about, tainted money. And I don't mean small amounts of money, but I mean a business, and it can be a small business. If you have profited out of slavery, we should make it a given that we do not want slavery money circulating around the world. That was one of the big things, how they combated the slave trade, the transatlantic slave trade. And if you look at the famous letter that President Lincoln sent to the people of Manchester in England, because the people in the cotton industry wouldn't buy cotton from the southern states of the United States, or at that time not the United States, but of the southern states, because that was funding the civil uprising, and it was also slavery and the cotton industry that was getting the money. So once the people stopped buying the cotton from the main part of the world, which was Manchester in the UK, and these were working class people, it brought down the slave trade in the US. And President Lincoln famously wrote a letter to the people of Manchester, thanking them for their efforts. And they were the people on the ground, people in poverty, working class people, actually played a role in that. So we need to think about this tainted money and just not have it We don't want it. We don't want anyone to profit from this abuse. It's so awful and abhorrent. The next thing we need to do is we have the internet. And the internet talks all about free speech. I was at an event in the Vatican with the big internet companies, and they said, but it's free speech. And I said, but you can't go in the middle of the street and abuse a child. You can't go down the road and start shouting obscenities outside someone's house. But you can have a computer inside someone's house in a child's room, and these acts can happen. Or it can be out in the Philippines and people can buy sex online. Or you can have all this pornography on there of children or people who are being trafficked, and you can recruit on it. And I said, you companies are earning hundreds of billions a year in profit. You have got the ability to reinvest that and stop this online. You can actually, and they talked about free speech. And I said, do ever talk about free speech when you're talking about child safety and child abuse. You cannot justify child abuse by saying it's free speech. It just doesn't work. So we need to legislate. They talked about they brought in apps and they're doing schools programs. So the problem on the internet is now an app for a parent, a busy parent, to understand how to stop this on their phone or their computer, and for a busy school teacher who should be teaching. The responsibility sits with the internet providers, businesses, and governments need to be strong enough and ethical enough to legislate and make sure that these companies do not profit from this form of exploitation and trafficking online. The next thing we need to do, the fourth thing, is look at the instruments, the slavery legislation back to the 1926, I think it is, the Slavery Convention, and use them, but modernize them. As Professor Fausto has seen, how can we use those in the international courts? How can we actually use that? Let's start getting those cases where we're holding people responsible as we would with terrorism or other serious crimes. And let's start looking at the businesses, their supply chains. Why is it we say it's too hard for a business to identify their supply chain when we can fly from London to Australia now? We can do all of these things. We heard about the exploitation that's happening in West Africa. And, we have the tire industry, which is making billions of dollars, and yet it's not investing back in its home countries where it's being grown. So let's start to look at the legislation and use it effectively. But this needs to be done by states, as was said by Alain. The next thing we need to do is engage, as this event is, engage with the international bodies, the UN, the ILO, the IOM, and start to shape what they're doing. Start to make sure that they're acting properly. They're not just doing campaigns, but that something comes out of it. When we get another convention signed, how can we make sure that convention is delivered? How can we say to our democratically elected governments, you signed that, you ratified that, you ratified the Council of Europe Convention, yet you're not delivering on it. Why not? But we need to work with like the World Health Organization, all these big international bodies, and just like Michel Veuthey's done, using their network to inform and start to get interest. And the final one, the sixth one, is we need to reset the moral compass. That may sound unachievable, but we need to start talking in plain English that this is unacceptable. We want to see the criminals face justice, even if that's a big multinational company. We want to see the legislation like the US Tariff Act used, which they have been using very effectively for the last few years, around stopping trade where there's slavery and not buying from countries where there's slavery. We want to see the UK Modern Slavery Act toughened up, the Australian Modern Slavery Act toughened up. We want to see the German legislation in action. We want to see the EU directives in action, because that's all about the moral compass. That's all about doing what's right for that person that I started off talking about, the marginalized. How often do we really think about the person who we will never meet? The person we will never meet, who today is packing our food, the person who is sewing our clothes, the person who is up getting the rubber for our tyres. Now, Germany has going a long way on their new legislation, and it is quite a high level entry at 466 million euros a year to be catched in it or caught in it, but that will go down year on year. But let's start to understand that. Let's start to talk about prevention. Prevention is always better. When they build a tower block in the United States, or whether it's in Thailand, they have fire exits. They have dry risers so water can get to the top. And thankfully, we don't get many high-rise buildings. Very tragic ones have happened, whereby people aren't safe. Well, that's what we need to do with modern slavery and human trafficking. We need to make systems where it can't happen. And if it does happen, you'll get caught. And if you get caught, you're going to face justice. And that justice may include jail time, but also it will mean that those people that you've exploited will get reparation. And that reparation will come from any profits you've made first off. So until we start to talk about this, as this event has been, like terrorism, like war crimes, and we start to get responsibilities of the states and across the world, and they start investing at least 150 billion US dollars a year to counter that money. And if we start going after that money, that 150 billion US dollars will become legitimate money because people won't be using it for slavery. So we need to think about it on a much more organized international level. But always remember that at the end of this, there's a life that's being destroyed, and we need to make sure that everything we do also supports them. So thank you very much.
Oh, thank you very much, Kevin. It's very powerful what you said. Also, very concrete, very very useful, I think. And I would love to hear also Professor Pocard. I'm pretty sure that you have first you have comments about what both Kevin Hyland and Alain Werner said. What to say?
Well, I listened with great interest to both speakers, to what they said, to Alain and Kevin, and I can only agree with them. Actually, what they said, I have nothing to say against. Especially, I find both interventions very powerful. And I will reflect myself on the list of devoirs that we should follow. But in essence, I believe it's like for other issues that we try to do an exploitation of children or what that has gone to some extent, and to stop making money out of what is illegal and unacceptable morally. So that's the real point at the end, because this is a big business. As always, it was always like that, because there is some misunderstanding in speaking in modern slavery. Modern slavery is not very different from old slavery, because at the end it was just exploitation of people for work and getting advantages. I mean, when one builds the pyramids with slaves, well, that's his work, exploiting work, and of course even the lives, because in such kinds of work people die also. So there are a number of features that put the two slaveries, what we call modern, is the oldest, contracting people, buying people actually, because paying and paying those who exploit. So that means what did the traffic of slaves, the transatlantic traffic of slaves? They were there too. There were mediators that were capturing the people in Africa and then making money, transferring there, and making money out of it. I mean, it's not much different. It's simply the techniques may be slightly different today because we have a modern technology actually to do the same. But the essence is still the old one, and one should find a way of saying that it is illegal, but also implement that it's legal making money out of certain activities. I mean, and so where it's done by small perpetrators, high-level perpetrators, multinationals, or whatever, it doesn't matter. But I think it's what has to be done, actually. Follow the money, and probably is the best way to arrive at the substance of the case.
Okay, thank you very much, Fausto. Actually, I see 4 questions. I don't know whether, possibly I will read them briefly, and whoever, Kevin or you, Fausto, if you want to answer them, please feel free, because normally we have 20 more minutes. And so first question is workers in the condition of slavery in agriculture, and mentioning especially in Italy. So workers in agriculture, and then I would just say that actually there was a report before the Human Rights Council precisely on this category of victims, and that was discussed last week in Geneva. Second question: pornography companies are protected and are better protected than children. That's the second question. The third is about the purchase of human organs for medical reasons. Is there any ethical restriction to safeguard the purchase of human organs? Of course, Kevin, you could speak also about this Council of Europe Convention against Human Trafficking. And then the fourth question is from Professor Elman Mad, a friend from Morocco. Thank you, Khalifa, for being with us. The gap between the law and its implementation is due to the ignorance of this law by many law practitioners. They are actually trained in private law, but not so much in anything dealing with human trafficking. So I don't know who would like to start answering. Possibly Kevin, would you like to pick up 1 or 2 questions? Please, you have the floor.
Yes, thank you. I'll start on the agricultural sector, and this is a big problem, and really it feeds into another question that was there really about companies. And we have this situation where migrant workers generally, and they may be migrant workers from within the EU. So there was a lot of problems in Italy with people from Romania, so it's not automatically people who are undocumented. And companies are, buying, and, they will do lots of checks on the quality of the goods, but not on the quality of the care of the staff. And, until they are properly held to account for that, and they keep saying to us, well, that will make things more expensive. Well, firstly, that's our choice if we want that. But the second thing is, it doesn't always make things. And there's organizations like the Institute of Human Rights and Business who have shown that if you've got a good workforce, and they're well paid, and agricultural workers are never going to get top salaries. They're always going to be lower paid, unskilled workers. But if they're paid properly and they're given bank accounts, they can really contribute to communities. And if we look at, over the years, as people have moved, my own family, Irish, went to America and then to the UK and then back to Ireland. It was all about economic movements. And once you could, my grandparents and my parents, once they got enough money, and then they went back and they built their own houses, and then that's how communities work. And, businesses and migrant workers are always, shortchanged literally, but then they can't get bank accounts. They've got no workers' rights. We need to work on that. We need to hold companies accountable. Your second point about organs, there are very strict rules around the world, and the World Health Organization and Dr. Frank Delmonico, who is the lead for organ transplants for the World Health Organization, has done so much work on this. There are policies, there's very strict rules in most countries around organs. But what you do end up with is, some countries and EU countries don't have donor policies at all. And so then what you end up with is that wealthy people from those regions who can't get an organ in their own jurisdiction, or, for example, they may have been refused an organ in their own jurisdiction because they're they're not medically suitable, they will travel to some places, and it's been known to happen in Egypt, India, some places in Africa, whereby then somebody donates an organ. And of course, it's not done in proper conditions. It's not done with proper follow-up and proper drugs. And if we look now, the media reports and the things I've seen firsthand, actually, of people coming from Afghanistan who have sold an organ, and families are doing it, and it's a big trade down there. And, the last Santa Mota group, we saw it firsthand on some photos about organs being sold in Mozambique. So, yes, it is it's well regulated within the regulated sector. Like everything, it can be regulated, and doctors aren't going to get involved in this. But then you've got this rogue area. But going back to where we were and where I was talking, and all three presenters have said, there isn't the investment in justice, in the state, and if this is state sponsored in some regions, or it's being done on a very large size, this should be something that should be looked at from the International Criminal Courts, because someone will die, the donor will die, and the recipient will die. And Frank Delmonico explains that far better than I could.
Ignorance of the law. I must say, as you know, as president, honorary president of the Sanremo Institute, we are very much into training military people, but possibly we should possibly training judges. We should be training, and we did train border guards about refugee law, but what about human trafficking?
You see, the problem is also, in my view at least, the problem is what came out of the last intervention of Kevin, actually, that you have to intervene also on situations in which persons may be favorable to trafficking their members of the family because they have no other option sometimes. And so selling one of the children for organs or other pornography, whatever, and saving the rest of the family is the only option that remains to some people. So you have to take into account also this situation, which goes also to the information about the law, of course, information of rights, but it has to be done properly, because sometimes I saw one of the questions, it's easy to speak of equality. One of the interventions speak of equality, but you must create a real equality, because otherwise there are desperate people. I mean, I saw these migrants here in the Mediterranean. Sometimes you have parents that put on the boat the child and they die. And they die, these parents, hoping that the child will arrive somewhere and have a future. So families that are in this situation and in these conditions may make sacrifices, either selling a person of the family in order to save the rest. But these are interventions have to be made also in that respect. I think it's not just a question of informing the people. One has to create a situation where we're not obliged to make certain choices.
Yes, Fausto, but anything about training?
Well, training, of course, is important. The more people, lawyers in particular, trained on these methods you have, the more you may have people that work on this topic, actually, which is important. And I'm a bit surprised, I said in my first intervention, that at high levels, like international judges, prosecutors should be, they pay no attention to this. It's ignorance? I don't think so, because they must know the law. I'm not sure they don't know the law, but an effort has to be made also in that respect, of course.
And if I could add there, Michel, to Fausto's point, is that investing in awareness with not just awareness is one thing, but as you say, Fausto, training of judges and law enforcement officials and those people, who are in critical positions, who may be able to see this, but also counter it and prevent it. So prevention goes much wider than the criminal justice system. Investment in those is critical, and that will take a number of years, and it needs a policy approach. But what I see all the time where I go is outsourcing. And I will see that, a country says we've trained 100 police officers or 200 or 300 police officers. And then I ask the question, well, how many police officers have you got? And they say 130,000. And every police officer will be trained in other crimes, and every police officer, for example, in the UK will have training on terrorism and what you should do at a terrorist incident or a death, a murder, or other serious crime. The chances of a police officer coming across terrorism in their service is almost, negligible. Some areas more likely, but actually it's negligible in the more rural areas. And even a murder, it's negligible. But they need to know and be trained in case they do. They're more likely to come across human trafficking. In fact, there's a good likelihood that they'll come across human trafficking, but they're not getting trained in it. But it's no good just training awareness. This is what it looks like. And we always train about awareness as to this is what a trafficked person looks like. Well, already we're in a way, saying this is what a victim looks like, when a victim could just look like any of us, could be quite a relaxed person, because sometimes they don't know. But we should be learning more about this is venues where trafficking happens. This kind of indicates that trafficking has happened. Money flows. One of the cases I investigated, when we got some very light intelligence, we started to look at the air flights. And we found that this group was booking one-way tickets for women, on air flights and coaches, all coming from Eastern European countries, no return flights. All the women were of a certain age, all paid for generally where they could by cash in these small little outlets. But then they started using credit cards. Then we looked at the finances and saw they had, on one occasion, one group, 49 flats in London. That is really serious organised. Just to have the numbers of people to go to those flats was enormous. They had to have, 200 or 300 women at least all the time. And so, if we're looking at it and we're not doing those things, if we think by setting up a number for people to ring or putting a poster up is going to prevent. And the first conference I did at the Vatican in 2014 at the Santa Marta group, I said, one of the phrases I used was the fact that, these traffickers are earning millions and they don't care what I say. They don't care even what the Pope says or any of us say, but they do care when somebody comes in at 5 o'clock in the morning and they end up getting a long time in prison and all their assets are taken. They get quite emotional then, I said. And then we can give that money. In the UK, the law allows it. to the victims as reparation. But we're not seeing that happening. The legislation's there. The UK has risk orders and prevention orders to act before a crime happens, used very rarely. If I was still in those roles now, I'd be using them all the time. But who is asking the question? Why are they not being used? Why are we told all the time the legislation's no good? Why are we told victims, oh, they don't want to cooperate? We need to change that because we're planning failure. That is planning failure. You know, if you want to win, you go out and you say, we're going to do this. This is how we're going to do it, and you achieve. And if we look at the way the world is now, if we look at Ukraine and the way the world has become so unstable, and we saw the Europol report today saying there has now been positive trafficking networks identified, you know, this is what we're up against. And we're not going to solve that by just raising awareness. I'm afraid we're going to have to engage with the criminal justice system, but also prevention, and hold those responsible and those systems responsible and those countries and those businesses who profit from it. This needs to be a crime that does not pay. And sadly, at the moment, it pays pretty well.
Thank you very much, Kevin. No, it's a very powerful also conclusion, I think, because we are closing to the end of our time. Let me say, really, I'm very grateful to all speakers and participants. I think we had a very good webinar, thanks to the three of you, and to also to the very good questions you asked. My special gratitude also goes to Yves Reichenbach, our webmaster, and to my assistant in Geneva, Clara Izeppi. The video recording of this webinar shall be available in a few days on a website at laudatosi.org with subtitles in English, French, German, Italian, Russian, Spanish, and Chinese. Feel free to share the link. Our English online course on human trafficking for helpers is now translated and available in French and English on the www.cuhd.org website, and feel free to access those resources. And I wish you all the best. I wish you all the best, and invite you to our upcoming webinars at the end of the summer and this autumn. We shall plan indeed a few more webinars. And thanks, and actually best wishes to all. And I don't know whether you, Kevin, you wanted to add something, Fausto? No, but clear.
Well, I just want to, you know, and also remember and thank all the people who make efforts to address this crime. And once again, Michel, thank you for your efforts.
Yeah. No, thank you. And thank you also for all people who attended, because I saw many people coming from not only Europe, but also Africa, America, and that's very good. And please, if you can share those videos, we will be very happy, and wish you all the best. So thanks you very much. And now goodbye to all. Thank you. Merci. Thank you, Kevin. Thank you, Fausto.